Get off this property. This is the Hargrove family lake house, and it has been since 2009. You need to leave right now.
She was standing in my doorway, holding a casserole dish, on a porch I'd paid $67,000 for 11 days ago. I didn't move. I didn't raise my voice. I looked at Donna Hargrove, 54 years old, former real estate agent, very certain expression, and I thought, she has absolutely no idea what she just stepped into. Because here's the thing about people who claim ownership without ever checking the paperwork. They tend to be very loud about it, very confident. They hang wind chimes on your porch, park their minivan in your driveway, and introduce themselves like they're doing you a favor by explaining the situation. What they don't do, what Donna Hargrove had very clearly never done, is walk the boundary line. Pull the deed. Check the county records. Find the iron survey pin sitting in the southeast corner of this lot that has had my name attached to it since the moment a federal bank auctioned this property and a cash buyer drove straight to the courthouse to record the transaction the same afternoon. She thought she was evicting a stranger from her family's lake house. She was actually standing on the one piece of ground in rural Kentucky where her confidence was going to cost her everything. I said, "Ma'am, before your husband gets here, do you have a copy of the deed?" She blinked, just once. Then she lifted the casserole dish slightly, like it proved something. That blink told me everything I needed to know about how this was going to end. How arrogant does a person have to be to change the locks on a house they never legally owned, and then act confused when the real owner shows up with a trailer full of tools? I want to be clear about something before I go further. I'm not a wealthy man who bought a vacation home on a whim. I'm a licensed contractor from Nashville, Tennessee. I'm 38 years old. I've been swinging a hammer since I was 16, working job sites since I was 22, and running my own crew since I was 29. I know what lumber costs. I know what labor costs. I know what it means to build something from nothing and watch someone else walk away with it. 2 years before I ever heard the name Hargrove, my business partner of 6 years, a man I trusted enough to share a joint account with, cleaned out everything we had and drove to Florida. No warning, no conversation, just a wire transfer and a disconnected phone number. I lost the business, lost the equipment, lost the contracts we've been building toward. I spent 4 months just trying to understand what had happened legally. I spent another 20 trying to rebuild. No vacations, no weekends, no version of this story where I feel sorry for myself, because that doesn't build anything. When I finally had $67,000 saved, I didn't buy a truck. I didn't take a trip. I spent 6 weeks driving back roads in 3 counties looking at foreclosed properties, land with problems, structures with damage, places other people had written off. I know how to fix things. I know how to read a site, and I know the difference between a property that looks hopeless and a property that actually is. The lakefront parcel in rural Kentucky was listed through a bank auction. Foreclosure proceedings had taken almost 3 years. The previous owner had defaulted, the bank had taken possession, and the property had sat vacant for 14 months by the time I drove out to look at it. Overgrown yard, cracked windows, a dock that had partially collapsed into the water, a kitchen that hadn't been updated since the early 90s. To most people, that's a money pit. To me, that's a weekend with the right crew and a clear plan. I walked the full boundary line the afternoon I came to inspect it. I found the iron survey pins at each corner. I noted the property lines, the setbacks, the access easement recorded on the adjacent parcel. I pulled the title history at the county clerk's office and read it twice. Chain of ownership, clear. Liens, cleared by the bank at foreclosure. Recorded deed, clean. I made the bid. I won the auction. I drove to the courthouse that same afternoon and recorded the deed in my name. Cash sale, legal transfer, everything documented the way it's supposed to be. That property was mine the moment the ink dried, and it was mine in every way that actually matters under Kentucky law before Donna Hargrove ever thought to hang wind chimes on the porch. The lake is quiet in the mornings. That's the only reason I bought it. Somewhere quiet to breathe again after 2 years of nothing but work and damage and starting over. I just hadn't expected to have to fight for that quiet before I'd unpacked a single box. I've worked with a lot of different kinds of people over the years: homeowners, developers, subcontractors, inspectors, city officials. You learn quickly that there are two types of people when a dispute comes up on a job site. The first type gets loud immediately. They argue at full volume from the first sentence. They talk over you. They repeat themselves. They confuse noise with leverage. In my experience, those are usually the people who don't have anything solid to stand on, because if you had the paperwork, you wouldn't need the volume. The second type gets quiet. They listen. They let the other person finish. They take note of every specific claim being made, every word chosen, every detail that can later be checked against a record. They don't correct you in the moment. They wait until they have something worth saying, and then they say it once. I am the second type. I learned that from my father, who built houses for 31 years in Middle Tennessee and never once raised his voice on a job site. He used to say, if you know what the contract says, you don't need to argue about it. You just open it. He kept every document he'd ever signed in a fireproof cabinet in his garage, organized by year, cross-referenced with a handwritten index. Title records, survey plats, easement agreements, tax receipts going back to 1974. When he passed, I kept the cabinet. I'm not a lawyer. I've never claimed to be. But I've pulled enough permits, read enough survey plats, and sat across enough tables from enough property attorneys to know what a clean chain of title looks like, and, more importantly, what it doesn't look like. I know the difference between a recorded instrument and a letter someone printed at home. I know what an easement actually grants versus what someone decided it grants because they'd been using something long enough to feel entitled to it. There's a specific kind of arrogance that comes from long-term use without documentation. People occupy a space for years. They start to feel ownership. They stop distinguishing between access and right, between custom and legal claim, between we've always done it this way and we have the legal right to continue doing it this way. Those are not the same thing. They have never been the same thing. When Donna Hargrove told me to leave my property, I didn't correct her on the spot. Not because I was unsure, I was not unsure, but because I wanted to understand exactly how far this went before I started opening cabinets. I already knew what the deed said. I already knew what the survey showed. What I didn't know yet was how many people were involved, how much they'd already done to the property, and whether any of it had been documented somewhere that would later become useful. I had a feeling it had. I took out my phone, hit record, and said, "Tell me more about that." Donna talked for 11 minutes without stopping. I know because my phone was recording the whole time, and I checked the timestamp later that night in my truck. Here's what she told me, in the order she told me. The Hargrove family had been coming to this lake since her husband Gary was a teenager. His parents had known the previous owner, a man named Earl Whitfield, since the 1980s. When Earl got sick and his finances started failing, Gary had made what Donna described as a gentleman's agreement with Earl's daughter, a woman named Sandra, to purchase the property before it went to the bank. They'd been making informal payments. They'd been maintaining the property. They'd been treating it as theirs for going on 2 years. Then I showed up. What Donna did not mention, what she may have genuinely not understood, was that a gentleman's agreement with Earl Whitfield's daughter carried exactly 0 legal weight once the bank initiated foreclosure proceedings. Sandra Whitfield did not own the property at the point of any alleged agreement. The bank did, and the bank had spent the better part of 3 years working through a formal federal foreclosure process, at the end of which they auctioned the property to the highest cash bidder. That bidder was me. None of that was hidden information. All of it was in the public record at the county courthouse, available to anyone willing to spend 45 minutes reading through filed documents. The foreclosure notice had been published in the local paper, as required by Kentucky law. The auction had been publicly listed. The deed transfer had been recorded. But here was the real problem, and this is what I understood standing on that porch while Donna talked. The Hargroves had 3 days earlier called the county assessor's office to file a nuisance complaint against the property. They had introduced themselves around town as the rightful owners being victimized by an outside investor. They had, in those 3 days, done a very effective job of becoming the sympathetic local family and making me the villain before I'd said a single word to anyone. The legal clock was already running. If they could drag this out long enough, make it expensive enough, complicated enough, embarrassing enough, there was a real chance I'd cut my losses and walk away from a $67,000 cash purchase rather than fight a prolonged battle in a county where I knew nobody. That was the actual strategy, not law, not documentation, attrition, and it was already working. Gary Hargrove arrived 20 minutes later in a black F250, driving it the way men drive trucks when they want you to know a truck is arriving. He pulled it diagonally across the driveway, blocking my trailer, boxing in my vehicle, and got out without turning off the engine. 57 years old, broad, the kind of tan that comes from actual outdoor work, not a vacation. He walked toward me with his thumbs hooked in his belt and his jaw set like he'd already decided how this conversation was going to go before he left the house. "You the one from Nashville?" "Ryan Caldwell," I said. "I own this property." He smiled at that, not a friendly smile, the smile of a man who has been told something he finds genuinely amusing. "Son," he said, "my family has been on this lake for 30 years. You want to talk about ownership, you're going to want a better lawyer than whoever sold you that story." I noted 2 things in that moment. First, he said lawyer, not deed, not title, not county record. He went straight to adversarial framing, which told me he'd already been talking to someone, or thought he had. Second, he called it a story, as if the foreclosure documentation, the bank's 3-year legal process, and the recorded deed at the courthouse were a narrative someone had constructed, rather than instruments filed in public record. I said, "Do you have a copy of the deed in your name?" He said, "I don't need a deed. We have an agreement." I let that sit for a second. Their son Cody was leaning against the minivan by then, phone up, filming. 26 years old, smirking the way people smirk when they think they're watching something that's about to go badly for someone else. I made a mental note that he was recording. I didn't ask him to stop. Let him film. Let all of it be documented. Then Donna produced the letter. It was printed on plain paper, no letterhead. Signed by Sandra Whitfield, Earl's daughter, stating that the Hargrove family had a prior informal agreement to purchase the property and that they were the intended buyers before bank interference. No bank signature, no notarization, no recording stamp from any county office, no acknowledgement from any legal or financial institution involved in the foreclosure, just Sandra Whitfield's signature on a piece of paper that had no more legal authority than a note slipped under a door. Gary held it out to me like it was a royal decree. I looked at it carefully. I read every word. I noted the date, which was, notably, printed 6 days after the bank auction had already closed. I handed it back. "You should hold on to that," I said. "You're going to want to show it to a judge." Gary's jaw tightened. What does it tell you about a person's actual claim when the best document they can produce is one they asked someone else to write for them after the sale was already done? The sheriff's deputy arrived 40 minutes after Gary called him. I knew Gary had called because Cody announced it out loud, with visible satisfaction, while I was unloading a level and a tape measure from my trailer. "Dad's got a deputy coming out. You might want to think about whether you really want to be here when he shows up." He said it the way 26-year-olds say things when they think the adult world is finally about to validate them. I kept unloading. Deputy's name was Tanner, young, polite. He had the slightly pained expression of a man who already knew, before he got out of the car, that whatever he was walking into was not going to be simple. He took statements from both sides, looked at Donna's letter, looked at the photo of my recorded deed I had pulled up on my phone, and delivered the line I had been expecting since the moment Gary blocked my driveway. "This is a civil matter, sir. You'll want to get yourself a lawyer." And there it was. I want to be honest about what I felt in that moment, because it wasn't nothing. There is something specifically exhausting about standing on land you legally own, with documentation you legally possess, and being told by a uniformed officer that the resolution to your problem is somewhere else. It's not rage exactly. It's a particular kind of tired. The kind that comes from understanding that being right and being helped are two entirely different things, and that the distance between them is measured in time and money and patience. I had a choice to make right there on that gravel driveway. I could push, demand the deputy acknowledge the deed, escalate the scene, let Gary's body language become a physical confrontation that Cody would film and upload before sundown, framing me as the aggressive Nashville outsider who'd come to intimidate a local family. That version of this story would be on the county Facebook group within the hour, and I'd already lost enough ground in the court of local opinion to know that wouldn't help me. Or I could do what I actually know how to do. Document everything. Move methodically. Build the kind of record that doesn't require anyone to take my word for anything, because the paperwork speaks clearly enough on its own. I thanked Deputy Tanner for his time. I took photographs of every unauthorized item on the property. The wind chimes, the minivan, the new padlock Donna had placed on the storage shed, the welcome mat with the letter H embroidered on it sitting in front of my front door. I photographed Gary's truck still blocking my trailer. I noted the timestamp on every image. Then I drove to the nearest gas station, bought a coffee, and called a property litigation attorney in Nashville. I didn't leave the property angry. I left it with a plan. There is a difference between retreating and repositioning. Gary Hargrove did not know which one he'd just watched. I drove back to Nashville that night and spent 2 hours at my kitchen table going through everything I had. Deed, bank foreclosure documentation, title search, survey plat, tax records, the photographs from that afternoon, the 11-minute audio recording of Donna's explanation on the porch, the timestamp on Gary's truck blocking my trailer, Cody's phone pointed at my face. I laid it all out, and I looked at the pattern, because there was a pattern. This wasn't a family that had stumbled onto the wrong property by accident. This was a family that had made a calculated decision. Sometime between the bank auction closing and my arrival 3 weeks later, that the most efficient path to keeping the lake house was not documentation. It was occupation, presence, community sympathy. The longer they were physically on the property, the more the story became their story. The more neighbors saw the Hargrove minivan in the driveway, the more the narrative calcified into, "That's the Hargrove place." They had filed the nuisance complaint 3 days before I arrived. That wasn't coincidence. Someone, maybe Donna, maybe a friend with half a real estate education, had told them that establishing a paper trail of grievance, however thin, was better than nothing. They weren't trying to win in court. They were trying to make court so expensive and so socially costly that I'd fold before we got there. What they hadn't accounted for was the specific type of person they were dealing with. I've rebuilt a business from zero after a partner stole everything I had. I've read survey plats by flashlight on job sites. I've sat across from contractors who tried to run the same attrition game on payment disputes, drag it out, make it painful, hope the other guy blinks. I don't blink. I looked at the survey plat one more time, traced the boundary line with my finger, found the recorded easement on the neighboring parcel, made a note of something in the title history I wanted to verify with the county clerk in person. Then I went to bed. They were standing on ground they didn't own, confident in a claim they'd never bothered to verify. That combination, arrogance plus ignorance, is the most predictable thing in the world to dismantle. You just have to be patient enough to let it finish building itself. Patricia Owens had been doing property litigation in Tennessee and Kentucky for 19 years. Her office was on the 4th floor of a building in downtown Nashville, and the walls were lined with the kind of organized binders that tell you immediately whether a lawyer is serious or decorative. Patricia was serious. I laid everything on her desk: deed, bank foreclosure file, survey plat, title history, the photographs, the audio recording, the printed letter Sandra Whitfield had signed 6 days after the auction closed. She read in silence for 4 minutes. Then she looked up and said the quietest, most satisfying sentence I'd heard in a long time. "They have nothing." I asked her to be specific, not because I doubted her, but because I wanted to understand exactly what nothing looked like in legal terms, so I could explain it clearly to myself before anyone tried to complicate it later. She walked me through it methodically. The foreclosure had been a federal proceeding. Once the bank initiated, all prior informal agreements, verbal, written, signed by any party other than the bank itself, became legally unenforceable against the property. Sandra Whitfield had no authority to promise a sale she could no longer deliver. The bank was the only entity with standing to transfer title, and the bank had done so through a public auction to the highest cash bidder. The deed was recorded. The transfer was clean. The Hargroves letter was not a legal instrument under any reading of Kentucky property law. What they had, Patricia said, was a civil nuisance complaint and a community reputation. What I had was a recorded deed, a clean title chain, and a federal foreclosure file with a judge's signature on it. She filed for quiet title action the following week, a formal legal proceeding that would require the Hargroves to produce, in writing, every document supporting their claim to the property, and would then measure those documents against the public record. I also did 3 other things that week. I called the county clerk's office and requested certified copies of every recorded instrument associated with the parcel going back 30 years. I contacted the surveying firm whose name appeared on the original plat and requested a boundary confirmation. And I started keeping a written log, date, time, description of every interaction, every call, every piece of correspondence related to the property. Patricia had said they had nothing. I wanted to make sure that when the time came, I had everything. While Patricia filed paperwork, the Hargroves got busy. Within 10 days of my first visit, Gary had replaced the broken lock on the storage shed with a heavy-duty deadbolt and added a second padlock on the dock gate. Donna had put curtains in the windows, my windows, and placed potted plants along the porch railing. Cody had posted 3 videos to his personal social media accounts describing the situation as a predatory Nashville investor trying to steal a family's lake house through legal loopholes. The videos got traction, not viral, but enough. Local shares, comments from people who knew the Hargrove name, who'd seen Gary at church or Donna at the school fundraiser. The framing was clean and sympathetic. Long-established local family versus outside money. It didn't matter that the framing was factually inverted. It landed. Then came the police report. Gary filed a formal complaint claiming I had threatened him during our first encounter on the driveway. Aggressive behavior, he said. Intimidating language. He wanted it on record. I heard about it from Patricia, who called me on a Tuesday morning with a tone that was professionally calm and personally annoyed. He filed a police report, she said. I know, I said. I have a gas station receipt time-stamped 40 miles from the property for the date and time he specified. A pause. Of course you do, she said. That receipt went into the file. But here's what the police report actually cost me, regardless of its complete lack of factual basis. It gave the local narrative another data point. Now there was a filed complaint. Now there was a record of an alleged incident. It didn't need to be true to be useful. It just needed to exist. Something Gary could reference in conversation. Something Cody could mention in his next video. Something that made me look like the aggressor in a dispute I hadn't started. I was being painted as the problem. Methodically, deliberately, on property I legally owned, using systems designed to protect people, weaponized against the one person in this situation who had actually done everything correctly. That specific kind of injustice has a weight to it that's hard to describe to someone who hasn't felt it. What do you do when the system built to protect your rights is being used as a weapon against them? 3 weeks after Patricia filed the quiet title action, I received a letter from a law firm in Lexington, 2 attorneys, a firm that handled, according to their website, real estate disputes, agricultural property law, and, listed third, like an afterthought, community property matters. Someone had referred the Hargroves upward. Gary had found himself actual legal representation. The letter was 4 pages. I read it twice, slowly, the way my father taught me to read anything with a law firm's letterhead on it. The core argument, stripped of its formal language, was this. The Hargrove family had maintained continuous physical presence on the property for an extended period, had made material improvements, had established community recognition as the property's occupants, and had a documented prior agreement, the Sandra Whitfield letter, demonstrating intent to purchase before the foreclosure concluded. They were asserting what the letter carefully termed equitable interest in the property and requesting that I cease all legal proceedings, vacate any claim of exclusive ownership, and enter mediation. Then came the sentence I'd been waiting for, buried in the third page, in the confident passive voice that lawyers use when they want something to sound like established fact rather than wishful argument. The subject property has been recognized within the community as Hargrove family property, and Mr. Caldwell's claim represents an attempted appropriation of a residence already under lawful private occupancy. Lawful private occupancy. On my property. With my recorded deed. After a federally supervised foreclosure auction. I called Patricia and read her that sentence out loud. She was quiet for a moment. Then, "They actually put that in writing." "They did," I said. "Good," she said, and I could hear her already thinking about how that sentence was going to look next to the foreclosure file in front of a judge. "Forward me the full letter. I want to respond formally before the end of the week." What struck me most wasn't the legal audacity of the claim. It was the confidence behind it. The Lexington attorneys hadn't filed this letter as a bluff. They believed it. Or at minimum, they believed that I didn't have the stomach or the resources to contest it properly. That the word mediation would look appealing enough to a lone contractor from Nashville that I'd take whatever they offered just to make it stop. They had the wrong contractor, and they had the wrong property. Because what nobody in that Lexington firm had apparently done, what Gary Hargrove had never once thought to do, was pull the full title history on that parcel and read every recorded instrument attached to it. Every single one. Patricia's response to the Lexington firm was 11 pages. I read every word of it before she sent it. It was one of the most methodical documents I have ever seen produced by another human being. She didn't argue emotionally. She didn't characterize the Hargroves. She simply laid the legal reality of the situation against every claim in their letter, line by line, with citation and recorded instrument reference attached to each rebuttal like a pin through a specimen. The foreclosure had been initiated by the lending institution in federal court. The proceeding had run for 31 months. Notice had been published in the county paper on 4 separate occasions, as required by Kentucky statute. The bank had obtained a judgment of foreclosure signed by a federal district judge. The property had been auctioned under court supervision. The deed had transferred to me as the highest cash bidder and had been recorded at the county clerk's office the same afternoon. The Sandra Whitfield letter, Patricia noted, was dated 6 days after auction close. Sandra Whitfield had held no ownership interest in the property at the time of signing, having lost all such interest at the point of foreclosure judgment. Her signature carried no legal authority over a title she did not possess. The letter was not a deed, not a contract, not a recorded instrument of any kind. It was, in Patricia's precise language, a personal correspondence with no cognizable legal effect on the chain of title. As for equitable interest, Patricia dismantled that in 3 paragraphs. Equitable interest claims require, at minimum, a demonstrable financial contribution toward purchase, a written agreement with the actual title holder, and reasonable reliance on that agreement. The Hargroves had made informal payments to Sandra Whitfield, a private individual with no ownership authority, not to the bank. There was no written agreement with the bank. There was no legal basis for reliance on Sandra's promise because any reasonable party conducting basic due diligence would have discovered the active foreclosure proceeding, which was public record. She concluded by noting that the Hargroves' continued physical occupation of the property, their installation of locks and personal property, and their filing of a nuisance complaint while claiming ownership constituted potential grounds for trespass and unlawful detainer action, and that if the matter was not resolved through the quiet title proceeding already filed, she was prepared to pursue those claims as well. The Lexington firm went quiet for 9 days. Then they requested a 60-day extension on the quiet title response deadline, citing need for additional discovery. Patricia granted 30. I drove back to the property that weekend, not to confront anyone, but to document. The Hargroves had added a second set of wind chimes, a bird feeder nailed directly into the porch railing, and a hand-painted wooden sign beside the front door that read, Hargrove Lake House, established 2009. I photographed all of it. I also photographed something more important, fresh concrete footings at the corner of the storage shed, where it looked like someone had begun preparing to pour a small addition. They were building on my property. There was a man named Delbert Cousins who owned the hardware store 2 miles from the lake. I found him by accident. I'd stopped in to price out some weather stripping. Optimistic, maybe, given the circumstances, but I needed to stay busy. And we got to talking the way you do in small hardware stores where the owner still works the counter himself. He was 71 years old, 3rd generation, had been selling lumber and fasteners to people in that county since before I was born. When I mentioned the property address, something shifted in his face. Not surprise exactly, more like recognition of something he'd been waiting to have a reason to say out loud. He told me he'd known Earl Whitfield for 40 years. Good man, he said. Careful man. The kind of man who kept his paperwork. He told me Earl had mentioned the Hargroves to him once, maybe 2 years before he got sick. Mentioned that Gary had approached him about buying the lake house someday. That Earl had said he'd think about it. And that Gary had apparently interpreted, I'll think about it, as something considerably more binding than Earl had intended. Then Delbert said something that I wrote down in my log that same evening, word for word. There's an old survey map of that whole lake parcel. Earl had it framed in his office. Showed the original boundary lines when the county first platted the lake properties back in 1962. I saw it a dozen times over the years. Always thought it was just decoration. But Earl used to say, he'd tap the frame and say, everything that matters about this land is already written down somewhere. You just have to know where to look. He didn't know where that map had ended up after Earl passed. Sandra had cleared out the house before the bank took possession. Could be anywhere. Could be gone. But he'd seen it. He knew what it showed. And he knew that the boundary lines on that 1962 plat did not match what the Hargroves had been telling people in town about where the property ended and the lake access began. I thanked Delbert and bought the weather stripping. On the drive back to Nashville, I called Patricia and told her about the 1962 plat. She told me to find it. How many times does the truth sit quietly in a frame on a wall while the wrong people argue loudly below it? The 30-day extension Patricia had granted the Lexington firm was down to 11 days when things accelerated. Cody posted a new video. This one was different from the others, less personal, more strategic. He'd clearly had help with the framing. The video laid out a timeline of the dispute, used the word investor 14 times, included a brief interview with a neighbor named Patsy, who said she'd always known the lake house as the Hargrove place, and ended with a direct appeal. If the community wanted to help the family fight a predatory out-of-state land grab, they could share the video and show up to the county commissioner's public meeting scheduled for the following Thursday. It got 400 shares in 2 days. Local news picked up the angle. A reporter from a regional outlet called Patricia's office asking for comment. Patricia declined, professionally, and called me immediately after. They're trying to create public pressure before the legal deadline, she said. If they can get the county commissioner involved, they create the appearance of a legitimate dispute at the municipal level. It doesn't change the law, but it changes the optics, and optics slow things down. I understood. They didn't need to win the legal argument. They needed to make the legal argument look complicated enough that a judge might hesitate, a commissioner might intervene, a timeline might stretch. Every week of delay cost me attorney fees. Every week of delay kept them physically on the property. Every week of delay was another week the community narrative hardened. Meanwhile, Patricia had received confirmation from the county building inspector's office that the concrete footings I'd photographed at the storage shed had been poured without a permit. Unpermitted construction on a property under active quiet title litigation. Gary had either not told his Lexington attorneys about the footings, or he had, and they hadn't stopped him, which said something troubling about the quality of advice he was receiving. Patricia filed an emergency motion to halt any further construction or modification to the property pending resolution of the quiet title action. The motion cited the unpermitted footings, the installation of additional locks, and the placement of permanent fixtures, including the hand-painted sign, as evidence of ongoing unauthorized alteration of contested property. The hearing on that motion was set for 8 days out. But what I was more focused on, what I'd been quietly working on for the past 2 weeks, was the 1962 plat map. Sandra Whitfield had cleared out Earl's house before the bank took possession. I'd tracked down Sandra through a mutual contact in the county. She was living in Bowling Green. She hadn't spoken to the Hargroves in months, and when I explained what I was looking for, there was a long pause on the phone before she said, "I think I know exactly which map you mean. I kept a box of Dad's papers. I haven't opened it since the funeral." Sandra Whitfield met me at a Cracker Barrel off I-65 in Bowling Green on a Wednesday morning. She was 61 years old, quiet, with the particular exhaustion of someone who had spent the last 2 years managing her father's death and its financial aftermath simultaneously. She brought a banker's box sealed with packing tape, set it on the table between us, and said, "I haven't looked at most of this. Dad was meticulous. I wasn't ready to be." I told her I understood. I didn't rush her. She cut the tape herself and started going through it slowly. Tax receipts, utility records, a folder of correspondence with the bank going back 8 years, a hand-drawn sketch of the dock layout Earl had apparently made when he first built it in 1991. And then, near the bottom, rolled and held with a rubber band that had partially disintegrated with age, a large format document printed on linen paper the color of old cream. The 1962 county plat map of the Lake District. I unrolled it carefully on the table, using our coffee cups to hold the corners flat. It was exactly what Delbert Cousins had described. Original boundary surveys of every parcel platted around the lake when the county first subdivided the land. Hand-drafted, precise. Each lot numbered, each boundary line measured in chains and links. Each corner referenced to a permanent monument. The surveyor's seal was still clear in the bottom right corner. County recorder's stamp beside it. I found Earl Whitfield's parcel, my parcel, in the northeast quadrant of the map. And there it was. The boundary line on the 1962 plat extended 47 feet further along the lakeshore than the Hargroves had been claiming in their community narrative. The strip of land between the property's southern edge and the public boat launch, the strip Gary had been telling neighbors was shared lake access belonging to the whole community and therefore not exclusively mine to control, was, according to the original county plat, entirely within the recorded boundaries of the Whitfield parcel. My parcel. But that wasn't the part that made Patricia go quiet on the phone when I described it to her later that evening. The part that made her quiet was the easement notation in the lower left corner of the map. A recorded access easement, number 1962-114 in the county registry, granting the adjacent parcel to the west a right-of-way across the southern edge of the Whitfield property for the purpose of lake access. The easement was granted for a period of 40 years, renewable by mutual written agreement of both property owners. It had expired in 2002, not renewed. No recorded renewal instrument existed in the county registry. Patricia confirmed this the following morning after pulling the easement file herself. The access path the Hargroves had been using, the path Gary had described to neighbors as the community's historic right-of-way to the water, was a dead easement on my private property. They hadn't just been occupying my house, they had been using my land as a public thoroughfare based on a legal right that had ceased to exist 22 years ago. "Ryan," Patricia said, and I could hear her choosing her next words carefully, "this changes the scope of what we can do here considerably." The county commissioner's public meeting was on a Thursday night. I didn't go. Patricia advised against it. "Anything you say in that room gets clipped, reframed, and posted by Cody before you get back to your truck," she said. "Let them have the room. Let them talk. We have the courthouse." So I stayed in Nashville and watched it happen from a distance. Cody live-streamed the whole thing. 43 minutes. Gary spoke for 8 of them, calm and measured in a way I hadn't seen from him before. Someone had coached him. He described the family's 30-year connection to the lake, Earl Whitfield's friendship with his father, the informal agreement, the shock of discovering the property had been auctioned without their knowledge. He used the word home 11 times. He never once mentioned that the foreclosure had been public record for 3 years. Donna cried, quietly, genuinely, in a way that read as completely authentic on a phone screen. Whatever else she was, Donna Hargrove was not performing that grief. She had built a life around that lake house in her mind, and she believed in her version of events with a completeness that made her sympathetic even to me, sitting alone in my kitchen watching a live stream of a meeting about my own property. The commissioner, an elected official named Briggs, who had, Patricia told me, received a campaign contribution from Gary's employer 2 cycles ago, made a statement expressing his concern about outside investment interests disrupting established community bonds, and said he would be writing a letter to the court expressing the county's interest in a fair and community-sensitive resolution. It wasn't legally meaningful. A commissioner's letter carries no weight in a quiet title proceeding, but it was something Cody could screenshot, something the regional news outlet could quote, something that made it look, to anyone not reading the actual court filings, like the local government was on the Hargroves' side. The video got 800 shares overnight. By Friday morning, 2 people had left 1-star reviews on my contracting business's Google page, reviews from accounts with no prior history, no photos, no other activity. One called me a predatory land thief. The other said I had no respect for community. My contracting business, in Nashville, 4 hours away. They had found it, targeted it, and used it. I sat with that for a long time on Friday morning. This was the part of the strategy I hadn't fully accounted for. Not the legal maneuvering, which I'd expected, but the reach. The willingness to go beyond the property dispute and touch the thing I'd spent 2 years rebuilding after my partner destroyed it. My business, my name, my livelihood. That was the false defeat I'd been building toward without knowing it. Not losing the property. I was never going to lose the property. But watching the collateral damage spread in real time while I held documents that hadn't been entered into evidence yet. Watching people believe the wrong story because the right story was still moving through a legal process that doesn't care about Facebook shares or Google reviews. I had everything I needed to end this. The hearing on Patricia's emergency construction motion was in 4 days. I drove back to Kentucky that Sunday with the 1962 plat map, Sandra Whitfield's notarized statement confirming the document's origin and chain of custody, and certified copies of the expired easement file from the county registry. I also brought my full set of demo tools, not as a statement, just because, one way or another, I was going to start on that kitchen. What does it cost a person, really cost them, to watch something they built with their own hands get used as a weapon against them? I want to tell you about the dock. Not the dock as it was when I bought the property, half collapsed, 2 boards missing, 1 support post leaning at an angle that told me the footing had shifted sometime in the last hard winter. I mean the dock as Earl Whitfield had built it in 1991, according to the hand-drawn sketch Sandra had kept in that banker's box. 8 feet wide, 30 feet out over the water. A small bench at the end, facing east, positioned specifically to catch the morning light coming off the lake. Sandra told me, sitting at that Cracker Barrel table, that her father had built it the summer her mother was diagnosed. He'd worked on it every evening after the hospital visits, didn't hire anyone, cut and set every board himself. When her mother came home after the second round of treatment, Earl had walked her out to the end of that dock at sunrise, and they'd sat on that bench together and watched the light come up over the water. Her mother lived 11 more years after that diagnosis. Earl had maintained the dock the entire time, replaced boards as they weathered, reinforced the posts after a bad ice year. When her mother finally passed, Earl had scattered her ashes from the end of it. Sandra said she didn't know why she was telling me this. She said she supposed she wanted someone to know the history of the place before it became whatever it was going to become next. I told her I was going to rebuild the dock. Same dimensions, same orientation. Bench at the end, facing east. She looked at me for a moment across the table and then looked down at her coffee and didn't say anything else about it. That conversation was sitting in my chest the entire drive back from Bowling Green. It was sitting there when I watched Cody's live stream. It was sitting there when I saw the 1-star reviews on my business page. It was sitting there on Sunday when I loaded the truck and drove back to Kentucky. There are properties and there are places. Most of what I work on professionally are properties, structures with dimensions and values and replacement costs. This was a place. Earl Whitfield had built something worth protecting on that land. The least I could do was protect it correctly. The hearing was scheduled for 10 in the morning in a courtroom on the second floor of the county courthouse. I arrived at 8:30. Patricia was already there, 2 banker's boxes on the table in front of her, organized with the same precision as her office walls. She had flagged every document with colored tabs, blue for recorded instruments, yellow for correspondence, red for the Hargroves filings. The red tabs were thin, the blue tabs were not. Gary and Donna arrived at 9:50 with their 2 Lexington attorneys. Gary was wearing a pressed shirt I hadn't seen before. Donna had dressed carefully. Cody was in the hallway with his phone, testing angles through the doorway until the clerk told him cameras were not permitted inside the courtroom. He sat down on a bench outside, looking like someone had canceled Christmas. The Lexington attorneys brought 3 documents: the Sandra Whitfield letter, a sworn affidavit from neighbor Patsy confirming the Hargroves' long presence at the lake house, and Commissioner Briggs' letter expressing the county's interest in a community-sensitive resolution. They arranged these on their table with the confidence of people who had not yet understood what was on Patricia's table. The judge was a woman named Elaine Morrow, 63 years old. She had been on the Kentucky bench for 17 years and had the particular economy of motion that comes from presiding over thousands of hearings. No wasted words, no performative patience, just forward movement toward resolution. She reviewed the case summary, then she looked up. "Ms. Owens, walk me through the plaintiff's chain of title." Patricia stood. She started with the original 1962 county plat, the linen paper map, now in a protective sleeve, entered as Exhibit A. She identified the parcel, the recorded boundary lines, the surveyor's seal, the county recorder's stamp. She noted that the boundary lines on the plat extended 47 feet further along the lakeshore than the defendants had been representing to the community, and she referenced the iron survey pins still physically present on the property, confirming those boundaries. She moved to the foreclosure file. Exhibit B, the federal court docket, 31 months of proceedings, 4 published notices in the county paper, the judgment of foreclosure signed by the federal district judge, the supervised auction record, and the deed transfer to Ryan Caldwell, recorded at the county clerk's office the same afternoon as the auction. She placed the recorded deed on top. Exhibit C, she read the legal description aloud, slowly. Every meets and bounds reference, every monument citation, connecting each line back to the 1962 plat now sitting in front of the judge as Exhibit A. Then she turned to the easement. Exhibit D, certified copy of easement number 1962-114 from the county registry. 40-year access easement granted to the adjacent western parcel, expiration date 2002. Exhibit E, Patricia's search confirmation, signed by the county clerk, showing no recorded renewal instrument of any kind in the 22 years since expiration. "Your Honor," Patricia said, "the access path the defendants have described to their neighbors as a historic community right-of-way is a private expired easement on my client's property. It has carried no legal force since 2002. Every use of that path since that date has been permissive at best, trespass at worst." She sat down. Judge Morrow looked at the Lexington attorneys. The senior one stood. He presented the Sandra Whitfield letter. He described the family's long relationship with the property. He cited the affidavit from Patsy. He referenced Commissioner Briggs' letter. He used the phrase equitable interest 4 times and community recognition 3 times. Judge Morrow let him finish. Then she picked up the Sandra Whitfield letter and read it in silence for approximately 15 seconds. "Counsel," she said. Ms. Whitfield signed this document 6 days after the auction closed. At the time of signing, did Ms. Whitfield hold any recorded ownership interest in the subject property? A pause that lasted slightly too long. She was the prior owner's daughter, Your Honor, and that wasn't my question. Did she hold any recorded ownership interest at the time of signing? The foreclosure had concluded, Your Honor. However, the equitable, so no, Judge Morrow said. Not unkindly, simply, the way you close a door. She reviewed Patricia's documents for 4 minutes in silence. The courtroom was very quiet. I watched Gary's jaw work slightly, the way it had on the driveway the first day, that same muscle moving under the skin. Donna had her hands folded on the table and was looking at them. Judge Morrow looked up. The plaintiff holds a recorded deed conveying clear title through a federally supervised foreclosure proceeding. The chain of title is unambiguous and uncontested by any instrument of comparable legal standing. The defendant's claim rests on a post-auction letter from a party who held no ownership interest at signing, an affidavit attesting to occupancy rather than title, and a commissioner's letter which carries no legal weight in a title proceeding. She set the papers down. I'm granting quiet title to the plaintiff. I'm also granting the emergency motion to halt further construction or modification of the property. The defendants are ordered to vacate the premises within 72 hours and to remove all personal property at that time. Any items remaining after 72 hours become property of the title holder. She looked at the Lexington attorneys. Counsel, I'd also strongly advise your clients to consult with you regarding the unpermitted construction already completed on the property. The plaintiff has reserved the right to pursue remediation costs. She gathered her papers. 19 minutes, start to finish. Outside in the hallway, Donna cried for Cody's phone camera. Gary told anyone who would listen that the system was corrupt. The Lexington attorneys spoke quietly to each other near the elevator, with the expressions of people recalculating a fee arrangement. I stood with Patricia on the courthouse steps in the November light, and she said, "Congratulations on your lake house." I said, "Thank you for reading every piece of paper." She said, "That's the job." I looked out at the parking lot. Gary's F250 was still there. Probably would be for a while. Some people need longer than others to understand that a thing is over, but it was over. The Hargroves called it a technicality. The rest of us call it property law. And the difference between those two descriptions tells you everything you need to know about why they lost. The Hargroves were gone within 48 hours. They took the wind chimes, the welcome mat, the potted plants, the bird feeder, and the hand-painted sign. They left behind 3 bags of trash, a broken lawn chair, and the unpermitted concrete footings at the corner of the storage shed, which I later had a structural engineer assess and a licensed crew remove at a cost of $2,400 that Patricia added to the remediation claim. The 2 fake Google reviews were reported and removed within a week. The Lexington firm sent a final letter acknowledging the court's ruling and confirming they would not be pursuing further action on the Hargroves' behalf. Cody posted one last video calling the outcome corrupt and proof the system protects investors over families. It got 41 views. He deleted it 11 days later. Commissioner Briggs did not write a follow-up letter. The remediation claim settled quietly 3 months later. I won't disclose the amount, but I will say it covered the legal fees, the engineer's assessment, the footing removal, and left enough to finish the dock materials with money to spare. I started on the kitchen demo the weekend after the Hargroves vacated, pulled the old cabinets, replaced the subfloor, reframed 2 walls that had water damage behind the drywall nobody had bothered to fix for 20 years. It took 4 weekends. I did most of it myself. The dock took longer. I wanted it right. Same dimensions as Earl's original sketch, 8 feet wide, 30 feet out. I used pressure-treated lumber for the frame and composite decking for the surface. More expensive, but it'll outlast anything Earl could have used in 1991. I set the bench at the end, facing east, exactly as he had drawn it. I poured the footings properly, with permits, inspected and signed off by the county building department. I finished it on a Saturday in early April, drove out alone, parked, walked down to the water's edge and out to the end of the dock, and sat on the bench as the sun came up over the lake. The water was flat and silver in the early light. A heron was working the shallows on the far bank. Somewhere back in the tree line, a woodpecker was already at it. I thought about Earl Whitfield sitting in this same orientation, watching this same light in a different year after a hard thing had passed. 3 of my neighbors, people who had initially believed the Hargroves' version of events, came by separately in the weeks after the ruling to introduce themselves properly and apologize for the confusion. I didn't hold it against them. People believe what they're told until they're shown something different. That's not malice. That's just how information works. I have a standing Friday dinner invitation from 2 of them now. The lake is quiet in the mornings. The dock is solid underfoot. The deed is in a fireproof cabinet in the storage shed, organized by date, cross-referenced in a handwritten index. My father would have approved. If someone tried to take the place you'd fought hardest to keep, and you had every piece of paper to prove it was yours, what would you do differently than I did? Leave your answer below, and if this story meant something to you, share it with someone who needed to hear it today.